Folks, I told you before you left that when we come back, the attorneys will make their opening statements. That's their opportunity to lay out the roadmap from their side of the case and tell you what to expect during the trial. As I told you before, those things and those statements by counsel are not evidence. They're simply going to tell you what to expect, and it's not meant for argument. So the idea is to give you a guideline, basically, to follow along. When they are done, I expect we'll start having witnesses or exhibits brought in. One thing you should know is there's only going to be one witness at a time coming in. That's called sequestration. Either one or both of those attorneys have the right to do that by law. And I'll advise, if you're wondering why, I'll advise those witnesses when they come on the stand and when they leave that they're not to discuss the case with anyone until it's done. Okay, so that's the purpose of me doing that. State ready to make its opening statement?
The state is, Your Honor.
Okay, you may do so. Thank you.
Thank you. Did turn my mic on? Are you able to hear me? First of all, I want to sincerely thank each and every one of you for agreeing to serve as a juror on this case. And I know we say that a few different times during the course of these proceedings, but it really is sincere. And we understand it is a sacrifice for each and every one of you that are on the jury pool. You have to do a lot of shuffling of your lives. You have to come here every day and listen to lots of evidence, probably a lot of technical evidence, medical evidence, ballistic evidence, probably things that you have never, had to learn, aren't familiar with, and now you have to be really quick learners. And I understand it's a lot to absorb and it's exhausting. And for that, I appreciate all of you for the attention that I know you'll give to this case and the thoughtful deliberations that you'll give to it when you go back to the deliberation room. During jury selection, we kind of got to know a little bit about you guys as you each come up to the podium, and we asked you a few questions. Ms. Neufeld got to quiz you a little bit, as well as Mr. Moninger. So I thought it was only fair that maybe I share a little bit about myself. So my name is Carmel Matson, and I have been with the State's Attorney's Office since 2003. I started here in my third year of law school. I was hired as a legal intern, and I never left. Luckily, 2004, when I graduated, they had an open position, so I applied for it, and very thankful that they did offer me that position. So it's been a privilege to work these type of cases and represent the state in these matters. You are here today because a defendant has been charged with the murder of his mother, Lola Moore, with the murder of Officer Cody Holte with the Grand Forks Police Department, and with the attempted murders of Deputy Ron Nord, Deputy Kelly McLean, and Corporal Pat Torok. Defendant has also been charged with reckless endangerment, terrorizing, criminal mischief, and possessing marijuana with intent to deliver. Evidence will show that Deputy Nord and Deputy McLean were enforcing a judge's order to remove the defendant and his mom from an apartment on 17th Street South here in Grand Forks. You will learn that on May 27th of 2020, both of these deputies met up with the apartment manager, Andrew Horgy, that afternoon. And they all walked up to the defendant's apartment number 303 together. The testimony and the body cam evidence will show that when they got to apartment number 303, the deputies knocked, they announced they were with the sheriff's department, and they told the defendant why they were there. You will learn that the defendant refused to open the door that he had been formally evicted from. The apartment manager, Andrew Horgy, was standing with the deputies outside the door, and he handed the keys to that apartment to the deputies. They used that key and unlocked the door. You will learn that when the deputies tried to push the door open to that front door, it was barricaded. It was barricaded with a 2x4 and a chair. Deputies were able to unlodge that 2x4 and make entry into the apartment. I anticipate Kelly McLean will testify, and Deputy McLean will testify when they first entered that apartment, he looked down that short hallway, and at the very end of that hallway, you could see a door close. You will learn through the testimony that that door was the defendant's bedroom door. The deputies walked down that short hallway, walked to that bedroom door, and noticed that it was locked. They asked the apartment manager if he had a key to that door, that interior bedroom door. And the apartment manager didn't. This isn't something standard that he has in his units. You will also learn that at this time, the defendant's mom, Lola Moore, was also home. When the three of them were standing by the defendant's bedroom door, the deputies continually asked the defendant to come out of the bedroom. Deputy Nord was standing on one side of the bedroom door, and Deputy McLean and defendant's mom was standing on the other side. The defendant's mom was standing on the right side of Deputy McLean, about a foot behind him. Deputies continued to ask the defendant to open the door. They told the defendant's mom why they were there, told her they had eviction papers. The defendant continued to refuse to open that bedroom door, telling the deputies he wasn't going anywhere. Because defendant continued to refuse to open that door, the decision was made to force entry. You will learn that Deputy Nord forced entry into the bedroom door. The body cam evidence will show, and the testimony, that immediately after Deputy Nord kicked that door, the defendant opened fire. Deputy McLean's body cam video will show that Deputy Nord was standing right off to the side of that bedroom door, standing there, one hand down, eviction papers in the other. Deputy McLean was standing on the other side of the door, and the mom to his right, a little behind him. When defendant opened fire, Deputy McLean retreated to the bathroom, which was just down from the defendant's bedroom door. Deputy Nord started backing down that hallway, drew his weapon, and then returned fire. Video evidence in this case, the trajectory evidence, the ballistics evidence will all show that it was defendant's bullet that struck his mom on the right side of her head, killing her. The trajectory evidence will show that when defendant opened fire while he was in his bedroom, he's firing out his bedroom door and through the walls of his bedroom. Bullet going through his bedroom wall, hitting his mom in the head. When Deputy McLean was in the bathroom, he radioed for assistance. It was Corporal Pat Torok and Officer Cody Holte that were the first responding officers. Both of these officers made entry into the apartment. They were able to provide cover so that Deputy McLean could get out of that bathroom. You will learn that once these 4 officers were in the apartment, They were all standing in the living room, kitchen area. Living room, kitchen area is on one side of the apartment. The defendant's bedroom is on the other side of the apartment. They're all on one side of the apartment. You will learn that for approximately 14 minutes, these 4 officers attempted to convince the defendant to come out of the bedroom, convince him to give up his weapons, and you will learn that defendant continued to refuse. But after about 14 minutes, the body cam evidence and the testimony will show that defendant bolted out of his bedroom, went behind a divider wall. You could see on both sides, kitchen, living room down one side, or kitchen down one side, living room down the other side. And he's got this divider wall in front of him. He's going back and forth, firing at the deputies. You will learn that the defendant opened fire using an AK-74 assault rifle. It was at this time that Officer Cody Holte was fatally shot. Law enforcement again returned fire. After a defendant was struck several times to his extremities, he fell down, hollering that he was dead. His AK-74 assault rifle laying next to him, the magazine empty. Deputy McLean then cautiously approaches the defendant as he's laying in the hallway on the ground. This is about the time that other officers start entering the apartment. And when they enter the apartment, that allows Deputy McLean to secure the defendant and place him in handcuffs. Once he's placed in handcuffs, law enforcement carries him downstairs, places him on the grass outside so that he could receive medical care and be transported to Altru. Before a defendant was transported to Altru, still laying outside while paramedics worked on him, Deputy Buckmeyer noticed a pistol in the defendant's pants. He pulled out this pistol and noticed that it was loaded. It had a round in the chamber. Testimony will also show that officers located 2 magazines for the defendant's assault rifle outside, both of them loaded with 26 bullets. Deputy Prudhomme found one of these and handed it over to Buckmeyer. The other one was found in the defendant's pants pocket. Medical and the ballistic evidence will show that it was the defendant who killed his mom, Lola Moore. I anticipate Dr. Kaponen will testify. Dr. Kaponen will testify because he completed the autopsies on both Ms. Moore and Officer Holte. I anticipate Dr. Kaponen will testify that he retrieved bullet fragments out of Ms. Moore's head. These bullet fragments were sent to a ballistics expert in South Dakota. I anticipate you will hear from this ballistic expert, Franz Moritz. And I expect Mr. Moritz, after he has analyzed the bullet fragments, the defendant's weapon, the ammunition, and is familiar with all the law enforcement's weapons and ammunition, he will tell you that those rifle bullet fragments in Ms. Moore's head were consistent with the defendant's weapon, with the defendant's ammunition, and were inconsistent with law enforcement's weapons or ammunition. At the time that Ms. Moore was struck, there were 2 deputies in the apartment, Deputy McLean and Deputy Nord. Both of these deputies were using their duty-issued Glock pistols. Body cam evidence in this case will also show that it was the defendant who fatally shot Officer Cody Holte. I anticipate when you watch the video cam evidence of Deputy Nord, Deputy McLean, Corporal Torok, you will see that based upon the positioning of where all the officers were standing, the position where defendant was, the direction of the gunfire, that the bullet came from defendant's gun. I also anticipate that you will hear the ballistics expert talk about the bullet fragments that he analyzed in this case. Dr. Kaponen will testify that when he performed the autopsy on Officer Holte, he observed 3 entrance wounds and 3 exit wounds. And he was able to retrieve bullet fragments out of all of these locations. Again, these fragments were all sent to the ballistics expert in South Dakota. And I anticipate Mr. Maurice to testify that these bullet fragments, rifle bullet fragments, were consistent with defendant's weapon and defendant's ammunition and inconsistent with law enforcement's weapons and ammunition. Defendant has also been charged with the attempted murder of 3 law enforcement officers: Deputy Nord, Deputy McLean, Corporal Torok. I anticipate you will see the body cam evidence of all 3 of these law enforcement officers. You will not see the body cam footage of Officer Holte, as I anticipate the testimony to show that his body camera suffered damage during the gunfire, and the video was not able to be retrieved. You will first see these videos when each of these officers take the stand. And this video will be played at a normal speed. But because things happen so fast, the first volley of gunfire lasted 16 seconds. The second volley of gunfire lasted 19 seconds. I expect you will hear from Agent Derek Matson with BCI. Agent Matson was able to play that video at a slower rate of speed and pause it at key moments. When you watch this body cam video, when Agent Matson is on the stand, I anticipate you will see during that first volley of gunfire, you remember when Deputy Nord had kicked that door and fire immediately from the defendant? You will see in that video the bullet trail of a bullet go right by Deputy Nord's head as he's standing there holding those eviction papers. Testimony and evidence in this case will show that Deputy, at this time, during the first gunfire volley, Deputy McLean didn't even shoot his weapon. Deputy Nord didn't until he backed up down that hallway. I also anticipate you will hear testimony from the officers that at the second gunfire volley, when the defendant bolted out of his bedroom and kind of hid behind that divider wall, I anticipate they will tell you that when defendant was behind that divider wall, he was going back and forth, almost like he was gauging where all the officers were at. During this trial, you will see photos of just how many times the defendant fired his assault rifle in that apartment. How many times he shot directly towards Deputy McLean and Corporal Torak when they were standing in the living room and they were standing by a pool table trying to take cover and returning fire. You will see a window, an apartment window right behind them. And I anticipate you will see photographs of numerous bullet defects in that window right behind where they were standing. I also anticipate when you watch Deputy Nord's body cam at a slower rate of speed and pause it, you will see Deputy Nord kneeling down in the kitchen, right by the kitchen counter, and you will see the bullets striking that kitchen counter right by Deputy Nord's leg. You will also learn that Deputy Nord was shot in the upper portion of his leg. As I mentioned earlier, the defendant is also charged with reckless endangerment and terrorizing. He's charged with these two crimes for the danger that he placed others in, the fear that he placed others in, endangering the lives of the other tenants, the apartment manager that was standing right outside that door, with the civilians, with the other responding officers. I expect you will hear testimony that the defendant was firing a high-powered assault rifle inside this apartment building. He not only chose a high-powered assault rifle, but he chose a 5.45 full metal jacket bullet that I anticipate the testimony to be, these are the type of bullets that will maximize damage. I anticipate you'll hear testimony from several agents from the Bureau of Criminal Investigation. You will hear from Agent Quam and Agent Kraft. Both of these agents did a trajectory analysis and a shooting reconstruction of the crime scene. Through this testimony and the physical evidence, you will learn that one of defendant's bullets during this first volley of gunfire when he's in his bedroom, one of his bullets traveled out his bedroom, out his front apartment door, across the hallway, and into apartment number 301. I also anticipate you'll be able to see the door to apartment number 301 and see all the bullet defects going through his door. I also anticipate you'll hear from the tenant of apartment number 301, Martin Smith. And I expect Mr. Smith will testify that when he was home, he heard knocking out in the hallway. He looked through his peephole, and then he opened the door. He saw the deputies, and then he went back in his apartment, closing his door again. He was home at the time that these bullets were going through his front door. Not only were the lives of the tenants in defendant's apartment in danger, but also the lives of the tenants in the other buildings. I anticipate you will hear testimony that one of defendant's bullets went through that window, that window that was right behind Deputy McLean and Corporal Torak when they're in the living room by that pool table, that these bullets were going through that window. They traveled across the courtyard They traveled into the building across and into the living room of another tenant. I anticipate you will see photos showing just how many bullets the defendant fired and how he would have had to even reload. When these bullets were going through that window behind Deputy McLean and Corporal Torok, there were other responding officers that were right outside that window, right below it. I anticipate these officers will testify that when they were standing outside below this window and those bullets were coming through, it sounded like that police Bearcat that they were standing next to was taking fire. I also anticipate you will hear testimony from other tenants in the apartment building as well. And these tenants will explain to you where they were during this gunfire, what they were feeling, what they were thinking. The defendant has also been charged with criminal mischief for the damage that he caused to the apartment, to Andrew Horge's apartment building. I expect Mr. Horge will take the stand and testify that defendant's actions or the damage to his apartment was well over $10,000, the amount the state needs to show to prove the criminal mischief charge. During the course of this trial, you will learn that officers secured a search warrant and they searched the defendant's apartment after the shooting. You will learn that agents found bags of marijuana in his bedroom, a scale, a grinder, a large amount of cash. They also searched his cell phone. I anticipate Agent Carter will testify that based upon his training experience, these items that were in defendant's bedroom showed an intent to possess marijuana with intent to sell it. And I anticipate the text messages that are found on defendant's phone will further support and corroborate that defendant is selling marijuana. After all the evidence is presented, the testimonial evidence, the physical evidence, the video evidence, the photographic evidence, the medical evidence, the ballistic evidence, the trajectory analysis evidence, and the shooting reconstruction evidence. I will ask you when I stand up in closing argument that you find the defendant guilty of all charges, that you hold him accountable for his actions on May 27th of 2020, his fatal actions, just because he didn't want to be a victim. Thank you again for your time.
Thank you, Ms. Mattson. Mr. Mottinger, does the defense wish to do its opening statement or defer until the state rests?
We'll do it now, Judge.
Thank you.
Good afternoon. Get over here where everybody can see me. That was a pretty compelling opening statement. I've been doing this work for 41 years. It'll be 42 years coming October. By looking at me, you can tell that I've seen a lot more yesterdays than I'm going to see tomorrow's. One thing I do know is that it is my honor, my duty, my privilege to present Mr. Pendleton. Judge referred to these opening statements as being roadmaps where we think this case is going to go. I would guess that over the last 30 years, fortunately or unfortunately, depending on how you look at it, I've probably tried as many murder cases as anybody in the state of North Dakota. It doesn't mean anything to you, but it's important to me because I see my job at this point not necessarily to give you a roadmap, but a roadblock. You just heard half an hour presentation, really good presentation on lots of specific evidence that the state believes they're going to be able to show you. Jury studies tell us in many situations up to 80% of jurors make up their minds sometime during the opening statements. Surprising, isn't it? Never conducted such a study myself. Always thought it might be interesting to really know what goes on in a jury room, but we leave that to jurors. If you fall into that trap, if you make up your mind, if you're in the process of making up your mind already, you know what? We might as well all pack up our stuff and go home. Because the rest of these 2 weeks or 2.5 weeks be a monumental waste of everybody's time. Yours, mine, yours. Promised me. Took that oath. You promised the court when you took that oath. Give this man a fair trial. You can only do that if you listen to all the evidence before you start to make up your mind in terms of guilt or innocence. I have tried cases across the state of North Dakota, all the way from Dickinson to Williston, not cases here, tried cases in Fargo. And of one thing I'm certain, North Dakota juries are fair. North Dakota people, as a general rule, are fair. That certainly doesn't mean that they always do what I want them to do. They don't always do what the prosecution wants them to do. But they do listen. They do listen. Spent a lot of time last week putting together an opening statement. I got up here the day before we started jury selection. I took a look at it and I threw it away. I didn't like it. I worked on another one last night, most of which is right here. I don't like this one either. So I'm just going to talk to you. That's okay. Back in another life when I was married, we were kind of into antiques. I used to do a lot of work in court up in Hillsboro, and we had a break over noon one day. I went downtown to an antique store, and I found a big round oak dining room table. Had 2 leaves in it. It was pretty beat up. I think the guy who owned the antique store was a fellow by the name of Dave Eblin. I asked him where this table came from, and he said, well, it's kind of an interesting story. That table belonged to a bachelor Norwegian farmer who lived down the road. When I was a little boy, his mother was still alive, and we'd ride our bicycles down there, and she'd give us lemonade and cookies, and we'd sit around that table and talk to her, and then she'd shoo us home. But in later life, I'd go down and visit the guy that was living there. That was his table. Well, I took it home. He polished it up. He looked at that table. That table was a very interesting piece of furniture. There were some bite marks on one of the edges where some little kid had chewed on it. There were some hammer marks on the table where that old guy probably had tried to do some repair work. I started to think about that table. How many major decisions were made around that table? That family probably sat around that table and decided if they really needed to sell the milk cow so they could afford shoes for the kids for school. Probably sat around that table and wondered how they were going to convince the banker to give enough money to put a crop in. Hard, common sense, common talk discussions. The only way you're going to be effective as jurors is when you get into that jury room is to do that. Sometimes I think us lawyers make this way more complicated than it needs to be. We're all human beings. We talked in jury selection how we expect you to leave your preconceived notions and biases and prejudices outside. I think you're going to do your best to do that. We all can sit down and talk things over. Hopefully when you're done, you're going to come to a conclusion that's going to satisfy you. That conclusion might not satisfy me, might not satisfy my client, not satisfy the prosecution, might not satisfy those folks out there. But as long as you're satisfied with it, that's okay. There are no do-overs in this business. A man once told me time is like a river. If you touch the water when it flows by, you can never touch it again because it's gone. Come back. One chance at this. Doesn't do us any good, anybody else in this room any good. If 3 days after your hard work is done, you start to wonder whether or not you did the right thing. Enough of that. Enough of that. Some of the things I wanted to talk to you about, I wrote down last night. I am going to take some time and mention. Perspective and sequence. Those are two important words that can be applied to this case. Perhaps the two most important things you need to remember. Sequence in which things happened. I think the state did a pretty good job in laying that out. Remember in jury selection, we talked about perspectives. Law enforcement has a perspective on what happened here. Client, Mr. Pendleton, Salamah Pendleton has a perspective. Doesn't necessarily mean that either one of those perspectives is wrong. Might as well end the suspense right now. Salamah Pendleton has an absolute right not to testify. You might ask me, why is that? Under our system, he's presumed to be innocent. He doesn't have to prove anything to you. He can sit here silent. Judge, if he chose to do that, the judge would instruct you that you cannot use that silence against him. You can draw no inference from it. But unless something entirely unforeseen, unexpected happens during the course of the next few days, we'll hear Mr. Pendleton. He's got a story to tell. He wants to tell it. And we're looking forward to you hearing it. You're going to have to decide how all these pieces fit together, whether they fit at all. In opening instructions and in the state's opening statement, it was clearly indicated to you that there are multiple charges here, 9, I think. Each one of those has to be ultimately decided, and we're going to talk a lot more about this in closing. They're all independent of one another. They all have their own essential elements. You're going to have to consider each one individually. And again, that emphasizes the point that you have to listen to all the evidence before you start to put the pieces together. Nothing is ever as simple as it seems. Be believable. Be believed. You must be believable. Be believable. We must tell the truth, or at the very least, acknowledge the truth, even when it hurts. Even when it hurts. Mr. Pendleton is not going to deny he fired that rifle. He's not going to deny that he fired that rifle. I'm going to tell you why. You're going to see some pretty graphic body cam footage for the course of the next few days. I told you I've been around for a while. This is actually first case that I've been involved in when a jury is going to see body cam footage. Up until a few years ago, I've tried lots of cases. These folks have tried lots of cases too. He never had any video footage of crimes. It was just almost unheard of. Assaults, incidents the state thought was a crime. Defense might have thought it was something else. But as the years have gone by, there's so much security footage out there now, so many cameras, so many cell phones, that what's going to happen here over the course of the next few days, probably before long, is going to become the norm for a lot of trials. To some extent, it makes trying these cases a little easier. Sometimes it makes trying them a little harder. But the world in this courtroom has changed over the past few years. How that's going to affect the job you do, I don't know. I don't know. In this room, you folks are the final deciders what can be proven and what cannot. At the end of the day, it's going to be your call. Asking you, keep an open mind and to do your best. I probably could go on a lot longer, but going back to my college days, we're studying some of the Greek philosophers. There's a Greek philosopher, a mathematician by the name of Pythagoras, said that meaningful silence sometimes is better than meaningless words. Our job is not to sit up here and preach to you. At this point, our job is not to argue with you. My job right now is just to make sure that my client, member of your community, gets the same fair trial that everybody else in this building does. In closing, I want to tell you a little story. Sure, most of you remember that Harry Truman was president of the United States from 1945 to 1952. Some people say that he was an accidental president. But the only reason he ever got to be president was because Franklin Roosevelt died down in Warm Springs in 1945 at a stroke. I like to think that it wasn't an accident. I believe that Franklin Roosevelt knew he was sick, knew he was never going to survive his last term in office, and he wanted to make sure that the country was left in good hands. While President Truman served out that term, he was elected. He had his share of controversies, but he retired, went back to Independence, Missouri, where he lived until he was an old man. He died in 1972, I think. Times were a little different then, and once he got back to Independence every morning, Truman got up and took a long walk around town. Have any Secret Service protection? Times were different. Wasn't President Truman anymore. He was just Harry, and he was home. One day, a young man got up enough courage to walk up and ask him. He politely said, "Mr. Truman, can I ask you a question?" And they say that Mr. Truman looked at him and said, "Yes, son, what do you want to ask me?" He said, "Well, I was looking for a little bit of advice in terms of how I should live my life." Mr. Truman thought about it for a minute, and he said something along the lines of, "Work hard, do your best, be fair, don't get too big for your britches, trust in God, never, ever get a friend." Now, some of you might be wondering how that has any application, or how is that important to this particular case. I would ask you to think about the following. Work hard. Listen. Pay attention. Do your best. Follow the court's instructions. Be fair. Be fair to the state, fair to Mr. Pendleton. Most importantly, be fair to yourselves. Don't get too big for your britches. Remember, when you get in that room, each one of you is just as important to the other. Each one of you's recollection as to what the evidence was and what it means is just as important as the person sitting next to you. Finally, never, ever forget a friend. You may not personally know Mr. Pendleton. You may not consider him a friend. But you know what? He's a member of this community. He's one of you. And he's entitled to the same constitutional protections that every single one of us are. And you can't abrogate or shatter those protections simply because what happened here was a terrible, terrible tragedy. I have a lot more to say. The job this afternoon is pretty much done. Yours is just beginning. Work hard, do your best. Thank you for your time.
Thank you, Mr. Mottinger.